Ready, start. A perusal of the impugned order indicates that the High Court has proceeded on the premise that it was necessary to weed out ineligible candidates who had provisionally appeared in the preliminary examination by assuming that there was a likelihood of ineligible candidates securing appointment. We find that all these contentions raised by the respondents had been duly considered by the High Court when it dismissed their writ petition on 7/5/2024. In the facts of the present case, there was no occasion to invoke review jurisdiction and direct holding of a fresh main examination, more so when the advertisement had been issued on 17/11/2023 and the recruitment process continued till June 2024. The conduct of a second main examination, insofar as physically impaired candidates were concerned, would not inure to the benefit of the respondents, since the scope of those examinations was distinct and it was restricted only for physically impaired candidates. Even on this ground, review jurisdiction could not have been invoked. The affidavit filed by the registrar within bracket I and L bracket close pursuant to the order passed by this court on 8/8/2025 in the present special leave petition indicates in clear terms that no ineligible candidate, though successful in the main written examination, would be called for interview. Thus, the apprehension expressed by the respondents, though unfounded, stands answered. The impugned order dated 13/6/2024, passed by the High Court in exercise of review jurisdiction, is set aside. Review petition number 620 of 2024 filed by the respondents stands dismissed. The appellants shall conclude the recruitment process initiated pursuant to the advertisement dated 17/11/2023 at the earliest. The appeal is allowed in the aforesaid terms, leaving the parties to bear their own costs. Learned counsel representing the appellant bar council vehemently and fervently contended that the challenge laid to the cognizance order was premature and the High Court ought not to have entertained the writ petition filed by the respondent advocate against the interlocutory order of reference passed by the judge advocate of the Bar Council on the valid complaint filed by Khimji Devji Parmar. It was submitted that at the stage of taking cognizance of a complaint, detailed reasons are not required and a prima facie finding in the reference order that there are grounds to proceed against the advocate for misconduct would be sufficient for reference of the complaint to the DC. Furthermore, the orders passed by the State Bar Council are amenable to challenge before the Bar Council of India. He thus urged that the High Court committed patent jurisdictional error in entertaining the writ petition filed by the respondent advocate against the reference order and granting a stay on the proceedings before the DC. Per contra, learned counsel representing the respondent advocate fervently contended that the complaint filed by Sri Khimji Devji Parmar is ex facie malafide and malicious. The respondent had admittedly not represented the complainant and thus entertaining a complaint filed against the advocate of the opposite party is nothing short of a gross abuse of the process of law.